right, today we're digging into a Supreme Court case that, believe it or not, starts in a rubber factory but ends up basically defining our entire digital world. This is the story of Diamond versus Diehr, a legal fight that pits a really practical, sticky industrial problem against a pure mathematical formula. And in the process, it completely shapes the future of software. So let me just start with a question for you. What on earth could rubber tires possibly have in common with software code? I know, it sounds like a weird riddle, right? But the answer is actually found in a legal principle that, well, it paved the way for patenting the very software that runs our lives today. So here's how we're going to break it all down. First, we'll get into the sticky, real-world problem that started everything. Then we'll look at why the brilliant solution was actually rejected as an unpatentable formula. From there, we'll frame the huge question the Supreme Court had to answer, break down its game-changing ruling, and also hear the powerful warning from the justices who disagreed. And finally, we'll connect all the dots and see how this case really became the blueprint for software patents. So let's jump in. Okay, so our story doesn't begin in a courtroom or a tech lab. It starts in a factory with a very, very sticky problem. You see, for the entire rubber industry, the big challenge was figuring out how to perfectly cure synthetic rubber every single time without fail. Yeah, see, when you're molding rubber, you have to press it under heat for a very specific amount of time. But getting that time just right was incredibly hard. A few seconds too long and boom, the rubber's brittle and overcured. A few seconds too short and it's weak and undercured. And the main reason for this was that the temperature inside the mold was never consistent. It was always changing. This meant a ton of guesswork, a lot of waste, and products that were just all over the place in terms of quality. And this is where our inventors, James Diehr and Theodore Lutton, come in with a totally brilliant process. Instead of just guessing, they used sensors to constantly measure the real-time temperature inside the mold. Now, that live data was fed directly into a computer, which used a pretty famous mathematical formula, the Arrhenius equation, to recalculate the perfect cure time over and over again based on the actual temperature. And here's the kicker. Once the time in the press matched the computer's final calculation, the computer would automatically signal the press to open. It was precise, it was elegant, and it solved a huge industrial problem. So Diehr and Lutton, they go and file for a patent. Makes sense, right? But the U.S. Patent and Trademark Office shot them down. They rejected the application. Now, the government's argument wasn't that the process was useless or obvious. No, their argument was that it wasn't the type of thing you could patent in the first place. The heart of the invention, they said, was just a math formula running on a computer. And that's an abstract idea, not patentable. So the whole legal fight really zeroed in on this one specific law, 35 U.S.C. Section 101. The best way to think about Section 101 is as the main gatekeeper for the entire patent system. Before you can even get to questions like, is this new or is this clever, you have to get past this gate. If your invention is the right kind of thing, it gets through. If not, the patent office won't even look at it, no matter how amazing it is. And this slide really lays out the fundamental divide here. On one side, you've got the stuff you can patent, a process, a machine, things like that. But on the other side, you have these big concepts that are totally off limits. You can't patent a law of nature, like gravity. You can't patent a natural phenomenon, like lightning. And you definitely can't patent an abstract idea. Or, and this is the key for our story, a pure mathematical formula, like E equals mc squared. Now, the Patent Office felt they were on pretty solid ground here, because their whole argument was based on a major Supreme Court precedent called Gottschalk v. Benson. That case had already established that an algorithm, a procedure for solving a math problem, was an unpatentable abstract idea. So from the government's point of view, all Diehr and Lutton had done was take an old equation and run it on a computer. The only new thing was the algorithm, and that was off limits. So the legal battle just went back and forth and back and forth. The first patent examiner rejected it. The Patent Office's own internal appeals board, they agreed with the rejection. But then a specialized court, the Court of Customs and Patent Appeals, flipped the whole thing on its head and said, no, this is patentable. With the lower courts completely split, the stage was set for a final showdown at the U.S. Supreme Court. So this all boils down to one crucial question, a question with massive implications. The Supreme Court had to decide, does an otherwise patentable industrial process suddenly become unpatentable just because its most innovative part involves a mathematical formula and a computer? In 1981, the court finally gave its answer, and it was Squeaker, a razor-thin 5-4 decision.
The majority opinion, written by Justice Rehnquist, laid out a totally new way of looking at inventions, like this one.
And the verdict was Diehr and Lutton's process was patentable subject matter under Section 101. They got past the gatekeeper. But honestly, the really game-changing part wasn't the decision itself, but the reasoning, the why. Okay, this slide perfectly illustrates the heart of the whole case. On the left, you have the government's view. They wanted to dissect the invention into pieces. They said, look, you have some old steps, like closing a press, and you've added an unpatentable math formula. So old plus unpatentable equals still unpatentable. But the Supreme Court on the right said, no, that's the wrong way to look at it. You have to view the invention as a whole. It wasn't about patenting an equation. It was about patenting a new combination of steps that achieved a real physical result, transforming uncured rubber into a finished, cured product. And Justice Rehnquist drove this point home with this very quote. He said the clue to patentability is whether the process transforms an article into a different state or thing. And Diehr's process clearly did that. It took raw, uncured rubber and physically and chemically changed it. The computer and the formula didn't disqualify it. They were just an essential part of how that physical transformation happened. But hey, remember, this was a 5-4 decision. It was close. And the 4 justices in the minority, led by Justice Stevens, they wrote a really powerful dissent, basically warning that the majority had just made a huge mistake. Justice Stevens argued that the majority was totally misreading what the invention actually was. He said, look, these guys didn't discover anything new about curing rubber. All the physical parts of the process were old news. The only truly new part, the only real discovery here, was a new computer program for calculating the time. And since a computer program is just an algorithm, an abstract idea, he thought it should absolutely be unpatentable. You can really boil down the dissent's whole fear to this one question. Did the court just create a clever backdoor to let people patent pure mathematics? They were worried that now any smart lawyer could just take an unpatentable algorithm, tack it on to some trivial real-world activity, and bam, get a patent. It was a serious concern. So the dissenters were afraid a massive loophole had just been blown wide open. But whether you see it as a loophole or a necessary step forward, the majority's opinion became the law of the land. And its legacy, especially for the software industry, which was just getting started, well, it was revolutionary. This case about curing rubber literally became the legal blueprint for the entire digital age. The impact was just massive, and it was immediate. By saying that a computer-implemented process could be patented, Diehr basically gave the green light to the entire software industry. That view as a whole analysis, it became the new standard. And it drew that critical line we've been talking about. You can't patent the formula itself, but you can patent a specific, practical process that uses it to change something in the real world. This decision became the bedrock that allowed companies to protect their software, which in turn fueled the tech boom and shaped the world we live in today. So if there is one thing you take away from all this, let it be this right here. The key lesson from Diamond versus Diehr is that an invention isn't automatically off limits for a patent just because it uses a computer or a math formula. The real test is whether the process, when you look at it as a whole, is a practical application that actually transforms something. And that leaves us with a pretty fascinating question for the future, doesn't it? The principle from this case is that applying a formula can be part of a patentable invention, but what happens when AI starts inventing its own complex, transformative processes? As AI evolves from just a tool into a creator itself, our legal system is going to face a brand new challenge, forcing us all to ask who, or maybe what, is the inventor?